Mr. Horowitz, you're recognized for your opening statement.
Great. Thank you, Chairman Jordan, Ranking Member Plaskett, members of the subcommittee. Thank you for inviting me to testify today. Whistleblowers perform an important public service, and no employee should suffer reprisal for bringing forward information that they reasonably believe is evidence of waste, fraud, abuse, or a violation of law. As we've seen, employees with a security clearance are particularly vulnerable to retaliation because an employee's due process protections and right to appeal a security clearance suspension or revocation are more limited. Moreover, such employees can remain suspended without pay for lengthy periods of time before having an ability to contest the security clearance action. Federal law requires agencies to have an appeal process that enables employees alleging reprisal due to a security clearance revocation or suspension lasting more than 1 year to seek Inspector General review of the reprisal allegation. The law also requires government agencies to establish a review process that, to the extent practicable, permits individuals with a retaliation claim to retain their government employment status while the security clearance review is pending. In May 2024, my office issued a Management Advisory Memorandum, or MAM, finding that the department's then existing policy didn't include the required IG appeal process for suspensions. As we noted in the MAM, placing an employee who claims retaliation on unpaid suspension while a lengthy security clearance investigation is conducted can make it financially unrealistic for the employee to retain their government employee status. Moreover, it creates the risk that the security process can be misused as part of an inappropriate effort to encourage an employee to resign. I'm pleased that the department has promptly responded to our MAM's recommendations. Separately, we've also received complaints about the security clearance suspension and adjudication process that go beyond the issues detailed in our MAM, including allegations of inconsistent compliance with standard operating procedures on the opening of security investigations, highly inappropriate investigations being asked, inappropriate questions being asked of witnesses during the security clearance investigations, inconsistent outcomes on security clearance suspension determinations, the suspension and revocation of an employee's eligibility to hold a clearance based on race, and retaliation against employees for raising concerns to management about security clearance suspensions, investigations, and adjudications. These allegations raise serious issues, and I would note do not apply to only a subset of employees with certain political views or ideologies. During today's hearing, for both investigative and privacy reasons, the only whistleblower retaliation matter that I can discuss is the one involving Mr. Allen. I'm able to do so because Mr. Allen recently settled his employment claims with the FBI, or against the FBI, with the FBI reinstating his security clearance and agreeing to provide him back pay. Following the settlement, Mr. Allen withdrew the retaliation complaint he had filed with my office, resulting in the OIG closing our retaliation investigation. Mr. Allen also waived any privacy rights that might otherwise prohibit me from discussing our investigation of the claims. As a result, I'm able to discuss with you today the factual details we learned during our investigation, which will illustrate many of the systemic issues that we've seen with the security clearance process. For example, in Mr. Allen's case, his unpaid security clearance began in early 2022 and didn't end until the settlement in June 2024. Most employees in Mr. Allen's situation would find it unrealistic financially to retain their government employee status for over 2 years without pay, which is in tension with the law's requirement that agencies allow individuals claiming retaliation to retain their employment status while a security review is ongoing. There are a number of other particularly important policy issues relating to protecting whistleblowers from retaliation that I look forward to discussing today, including potential legislative issues and potential actions raised in the written testimony and correspondence submitted for today's hearing. And as we seek, all of us, I think, to ensure that the security clearance investigation and adjudication process is never used to retaliate against whistleblowers and people who bring forward, in good faith, claims of waste, misconduct, and abuse. Thank you again for the committee's support, and I look forward to answering your questions.